All right, good morning, everyone. Hi, Suzana.
Good morning, Ian.
We're just waiting for Jordy to join, and as the usual protocol, if everyone could mute and no video would be great, helps the stream. All right, so welcome to, it's week 8, I think it is, for our seminars. Who would have thought that we would be in the eighth week of a COVID seminars? But here we are. Jordy, welcome this morning. So Suzanne and Jordy, I think what we'd like to do today is we're going to talk a little bit about how our week went, but also talk about the internal elements of the drafting process. We've gone through a lot of execution discussions. We've gone through some of the intake discussions in a COVID environment. I'd like to spend some time today talking about the will document itself and the power of attorney document itself and some of the clauses to bring to highlight. So Jordy, why don't we 2 minutes ago chatted, and you could start with the discussion that we just mentioned about the anatomy of the will, if we could.
Great. Well, good morning, everybody. I'm hoping that I'm getting a little bit of a lag, so I hope it's not my email or my Wi-Fi. So good morning, everybody. Yeah, so I just thought maybe we could concentrate a little bit on the planning process and the will itself. So I'm going to just start with a screen share to talk about making it easier for clients to come up with decisions and making it easier for us to guide them. So I think we've talked about the 3-2-3 model before, but I just wanted to highlight some more specifics that that I typically deal with clients on. So we've talked about the fact that using a structure for guiding clients is very helpful for them. It's helpful for us too. It keeps us on track, but it's very helpful for a client, especially one who hasn't gone through the process maybe for a long time or ever, to know how they're going to come up with the decisions, because it can be very daunting. I mean, for us, we deal with it all the time, but for a client, obviously, it's a sort of you know, a new thing. So we've talked about, I think, the idea that we're breaking it down into 3 scenarios for a married couple with kids. What to do if you die and your spouse survives you, what to do if your spouse does not survive you but you have descendants, and then what do you want to do if everyone's gone. Those are the 3 scenarios, and we've again talked about the types of the way I talk to clients and Ian talks to clients about gifting, and the idea between absolute gifts being one option and the other option being trusts, where you use, I always say, if the client has used the word but, then you are describing a trust. So these slides are very helpful as a preliminary discussion with the client, for them to understand the framework of what they're going to do as far as decision making. And then the last part of it is really this idea of you know, how does a will work? And we describe it as a funnel that collects all of your assets when you die that are in your name. It separates assets that pass outside the estate by joint ownership or by right of survivorship or by beneficiary designation. There are filters for debts and taxes and expenses. Then the client can concentrate on any initial gifts of specific amounts or gifts of specific assets. And then lastly, everything flows through into this big bucket at the bottom, is the way I describe it, that we use percentages for. And of course, we know that is the residue. So that's sort of, we've talked a little bit about that. What I want to show is how to break down the different scenarios and for us to consider a way for guiding clients. And I'm a big believer in options and limiting options to some usable number. I mean, the options are unlimited. So if we put down every option, that wouldn't be that helpful. So So I always start with the surviving spouse scenario. And I say to the client, really, you've got three options here. You can leave everything to the spouse with no strings, and we talk about that. You can use some or all of the assets and use a spousal trust, and we can talk about that. And then the other option that we'll talk about is a gift immediately to someone other than the spouse. And these slides, I'm sure we can make them available to anybody who is interested in them, but very helpful for, I actually send these to the clients after the meeting. I probably should send it to them before. That would be better, save me some time. But so I go through the different options, the idea that, if you give everything to each other with no strings, the one thing I obviously want to make sure that they understand is that the survivor can do anything they want with it. One of the most common claims, and I'm sure Suzana, you can speak to this, is this idea that, when mom gave everything to dad with no strings, and then dad turned around and gave everything to his new spouse, she never would have done that if she had known, right? So.
Yeah, we definitely see a lot of those kinds of situations from a litigation perspective, and it is very difficult because from a planning perspective, I know it's a hard conversation to have when you're sitting in front of perhaps newlyweds who are, finally getting their affairs in order. And I think that the world is wonderful and will continue to be until the end. And these things happen. So difficult conversations, but things that we definitely want to raise with our clients so that at the end of the day, we're planning for all these possible scenarios.
And I put that right on the record. I say, understand that John or Susie can inherit everything and then can give it to their new spouse. And you can see their eyes sort of, recognize that. And then, okay, well, but I put that I put that on the record, right? Because I'm recording these conversations. So I'm hoping to avoid that kind of argument that they didn't really understand that concept.
And do you deal with, Suzana, on the retainer side? How do you address that when you're the intake stage?
There's a lot of different ways that people do this generally, and I see that there are some situations where lawyers will only act for spouses in first relationships. If they're in a second relationship situation, they will only act for one of the spouses and might send the other one out for independent representation, just so as to avoid these possible difficulties. And so I think from, the best way to deal with it is to sort of anticipate it and then document what you've ultimately decided or discussed with the clients, because as Jordy says, that's the only way we can protect ourselves.
Great. So that's the first. That's the first thing about this absolute. And then I say I do spend a few minutes, even if they say no, we want to leave everything to each other. I say, well, I just want you to understand what the other option is. And that is, of course, a spousal trust. And I pull up this slide, just so they understand what the option is before they jump to that, because I don't want them to just jump to that and not consider the other option. And so this is sort of how I explained how a trust might work. You would take, the asset or a percentage or the whole estate, put it in this trust here, and have a trustee who's in charge of that. And then you would make the rules about how the money flows from the trust to the spouse. And here are the types of rules you could make about that. You could have mandatory payments, for example, income, right? And you could talk about how that's required. You could give unlimited discretion to the trustee. You could limit to certain events or certain amounts or needs or things like that. And so I put in some of the most typical ones, but I explained, like, you can make up whatever rules you want, and that's your right. And whatever's left over when the spouse dies goes to the kids. And that's how you can protect that the kids may get something at the end, but it does prevent the surviving spouse, from giving this away to someone else. That's the main thing. And the last point second last point I make is that these people down here get to know what's going on about this trust. So, that often is the trigger for them rejecting it, is that the fact that, the kids and the government on behalf of unborn, I don't talk necessarily about that, but I just say, they're entitled to know about what's going on and ask, see accounting and things like that. So that's that.
Suzana, let's talk a minute about the accounting obligations when you're doing the intake with the client for a spousal trust scenario like this. What are you typically wanting to make sure the client knows and understands in the context of that?
I think it's just recognizing that it's an extra level of complexity that they have to be ready to accept, because an outright gift is so much more simpler than setting it up into a trust, which then requires a trustee, requires someone to actually administer the trust. And as you alluded to, Ian, annual tax returns have to be filed for the trust. So it just adds a little bit of complexity to what the trustee has to do in order to administer that over the course of the spousal trust.
And it really does come back to the question of the choice of trustee, making sure that you've got the right person who can, first of all, live long enough to consistently run the trust. If you pick someone age out of sync might be a problem. And second of all, someone who can run the business side of things, keep careful records and so on. And it might be just fine to be either the spouse, but it might not be, depending on the circumstances. Okay, so Jordy, do you want to continue on with your slides?
Yeah, so key to this whole point is the explanation to clients about joint assets and how those fit into this whole thing. Because one of the things, and I'm not obviously going through everything that I tell the client, but one of the first things I show the client is, look, if joint ownership is like a mini will. That's how I describe it for that asset. And if two people own something jointly, and I usually hold up a pen and show that, if two people own something jointly and one dies, they just fall right off title, which means that the other is the sole and absolute owner. So I can't give away my half of the pen because I don't own half. When I die, it's going to the other spouse. So explaining that to them, and if you don't want that, if you say, well, I want to give my half of the house, but then I say to them, well, you can't own it joint, right? And so that's all very crucial for estate planning. Obviously, having the client understand, obviously we all understand that, but making sure that the client recognizes, that joint ownership is like making a mini will for that asset.
Jordy, one of the questions we've been asked is to take it that next step too. I mean, when we're discussing the possibility of a spousal trust planning scenario, what are you talking to the client about in respect of not just joint assets, but the concepts of tenancies in common, changing designations, changing joint accounts, and so on? So,
yeah, I mean, obviously those all fit together. And I explained, obviously, that, you can, if you own everything jointly, then your will is in fact irrelevant if the other owner survives you. So we've got to take, obviously we have to consider all of the assets, and that, and this is something that clients miss often, is that the impact of ownership on the estate plans. So important. And I would say that Law Pro is especially concerned about this on the inadequate investigation side of things, that, ownership the type of ownership can completely destroy the estate plan, the intended estate plan. And so, I just had one yesterday where I had a whole discussion with somebody about properties that they wanted to go to certain people. And then I said, tell me, obviously I've got to do a title search, but, oh no, but it's all owned by a corporation. I'm like, well, that, glad I asked, because that's going to change everything that we talked about. And so it's important. And even if you ask them that, like, who's the owner, and oh, I own it. And then until you literally ask them, is there any corporation involved here? Oh yeah, there's a corporation, but I own the corporation, so I own it. It's like, right? Ownership's so important, and that's a real problem for us.
Just as an additional question we've been asked, and we appreciate all these in the chat line, please feel free to engage us. I just want to come back to, before we move on, and just you and Suzanne, I'll start with you, Jordy, though. You mentioned earlier about recording and the idea that you, can you tell us a little bit about what conversations or meetings are you recording with clients, A, and then B, Suzanna, what other thoughts do you have in regard to the documenting process? So Jordy, can you start?
Sure. So I used to only record, I used to use just audio recording of only certain meetings, not every meeting. I didn't record every meeting. You know, it was more depending on the significance of the red flags or things like that. Nowadays with Zoom, I'm basically recording every single meeting I have. I'm recording not only the audio, but I'm also recording the screen sharing, because with Zoom, I'm often screen sharing. And so I'm recording basically the whole interview, and putting all of those things on the record, you know, because there's often things we mention to clients that we don't document. If we're trying to there's no way you could possibly note everything that you say. You know, that's one of the benefits of recording, obviously, but one of the disadvantages to recording is it's a permanent record of what you said and what the client said and how they sounded and how you sounded and how you put the question and all of those things. But my belief is it's still better, you know, and makes checklists that much more important, because if you miss an issue, it's there forever.
Are you taking contemporaneous notes at the same time, Jordy, or any notes at all?
So the only thing I would note is something that I don't want the client to see. And that's a rare thing. You know, I'm putting basically it on the record. Like if there was something I wanted to remember, I might put notes down, but it's rare for me to do that. The one time that I do note taking is when I'm doing a will review with clients, and I'll pull that up in a second, but I have a sheet that I use, and it's not digital, it's actually manual, where I note any changes that I have to make to the will based on the draft after the discussions. It's just an easy way for me to make sure that I've checked off everything all the changes I need to make. But aside from that, I basically put it on the record. You know, I say to them as clearly as I can, tell them, you know, this is going to upset this person. Do you understand that? You know, well, I'll be gone, right? I'll be dead by then, so I don't care. Great, okay. So, you know, aside from other points you might want to add to that, I think that's so powerful. I think, you know, and you guys, Ian and Suzana, you tell me, but I think that is so powerful for a judge in a will defense case, you know, to hear the client say, yeah, I know it might upset them, but you know what? This is what I want to do. Yes, yeah, you can cross-examine, but you're hearing them, so yeah.
And I think also it'll have a lot of moral suasion to those beneficiaries who see, you know, that individual going, yeah, no, I know it's going to upset them, but this is what I want. So it's hard to fight the intention argument at that point, I think.
And I think
a lot harder than with notes.
For sure. The key too, though, is not stopping at that and saying, look, that's well and good, but you know, I'm here to do a will that we want to survive scrutiny of the courts later, and I need to know why, and I want to know your rationale behind it, and I want to document that. And just as an aside, if people can make sure they're muting their phones and so forth, because we're getting some background noise, and that would be great. Okay, so Jordy, we'll come back to your discussion now, but I just wanted to check with you. We got a question here. Is the statement of intention regarding jointly owned assets binding on the bank holding the assets? For example, the testator states his intentions that a certain account is jointly owned and will not pass by right of survivorship, but form part of his estate. Is the bank entitled to freeze the jointly held assets and require a certificate of appointment, etc.? Jordy, what do you think? Or
sorry.
Go ahead.
I just, so, you know, we're using this more and more combined with a separate secondary will to deal with these kinds of assets. So I think I mean, I'm not sure I'd put a statement, you know, necessarily in the will about that. I'd put a statement somewhere else. Because you know, the intention of the testator is that it does pass to the surviving joint tenant, but it's being held on a resulting trust for the estate, for example. And so is the bank entitled to do it? They're probably entitled to do it in the sense that they could say, well, you get a court order, but I see more the other side where they say, look, we're relying on our form, on our bank form, and so we're going to pass it. And if you guys want to fight about it, go ahead. But we're entitled to delete the testator's name from the joint account and leave it just to the remaining owner.
And that's
All right,
certainly what I've
go
seen
ahead,
too.
Suzanne.
Yeah, that's certainly what I've seen in the past. The banks are careful to just rely on their own internal documentation, don't want to get into any kind of a scuffle, and they leave it to the parties who are disputing it to go and seek some remedy from the court.
Okay, great. Well, thank you. We'll keep moving on. And as I say, I welcome any questions and we'll try to get to all of them. Jordy, can you continue with your review of the slide?
Sure. So that's the spousal trust scenario. And ultimately the client, we work with the client, and again, we use that software to do that and demonstrate it and that kind of thing. But so then we move to the second scenario, and this is descendants only. So the spouse is not alive and the kids are alive. So these are the sort of things that I generally go over with the client. Are there going to be any initial gifts to anyone other than the kids? That's the first question. Let's get that out of the way. And then we'll talk about the idea of, trusts for any recreational properties or the home. And I'll maybe raise that in a moment. But the key obviously is, what are we going to do with the residue? And as I always tell clients, in 500 years of estate planning, we've only come up with two options for you. And that's either we give it to the kids with no strings, or we don't want them to get it all at one time immediately on death, so we need a trust. And so the way sometimes clients get intimidated by the idea of a trust, and so I try to break it down into, I say, look, there's only about 4 items that we got to worry about. And the first one is, how long is this trust going to last? Is it going to last for the rest of their lifetime, for the child's lifetime, or is it going to be to a certain age? And then I just simply explain, if a child's 50 when you die, do you want them to get their money with no strings? And they say, well, yeah, of course. And I say, okay, so what's that age where you'd be okay with the child getting that money? And that's the duration. And then I explain that really, then we just have to talk about how money is going to come out of the trust to the child before they turn that age, and explain to them, you've got discretionary and payments, but the other option you have is what I call mandatory payments. And those are payments that must be made to the beneficiary. So for example, a child gets 30% when they hit 25. Well, they don't have to ask for that money. It comes to them with no request necessary. It's automatic. But the downside to that is it comes to them without request and it's automatic. In other words, you can't withhold that amount. And so you've got to be okay with that. So that's the idea of mandatory payments. And I go through the different kinds of mandatory payments you can have: lump sums, annual amounts, payment of specific income, for example, things like that. And then, the gift over is pretty natural in this scenario, but this applies to any kind of trust. Who's going to get it when the trust is over, or if the beneficiary dies before the end of the trust. And the last thing, and I think, Suzana, you're going to talk a little bit more about this, is, the big decision might be who's going to be the trustee, who's going to be in charge of this. And that's often the most important and the most difficult issue.
Yeah, we see a lot of estate fights over, the choice of trustee. And I imagine from a planning perspective, a lot of consideration goes into who's ideally suited for that role, because, it is a business kind of role in the sense that you are making and administering a trust. You're keeping very detailed records as a trustee so that at the end of the day, you can actually account for your trusteeship. But a difficult and emotional decision for many people, I know, because you're choosing one person perhaps over another, or you're choosing more than one person, and that brings its own complexities. So all of these are discussions that we're having during the planning process to make sure that we're helping the clients choose the best candidate for that role.
And people are often very concerned about their ability, the choice, being able to make a great investment person, or, I mean, my bias is towards shared values in this role, in the role of trustee for the kids' money. I think where there's so much discretion, I think shared values and trust are the key elements. As I say, to clients all the time, you can hire an investment person, you can hire a lawyer and an accountant and all that stuff, but pick somebody with good judgment and with shared values. That's really the number one. And not to forget, which is something that clients often don't think about, and sometimes we don't think about it enough, is the dynamic that's created between the trustee and the beneficiary. So if they're, the first person they pick is, oh yeah, it was very close. Uncle is very close to nephew. Okay, just understand something, that's going to change the relationship from just uncle nephew to trustee beneficiary, which could have a dramatic impact on, or else we wouldn't be in business, right? A dramatic impact on that relationship.
And add, of course, sorry, and I was just going to say, and add to that, the entitlement to compensation is also one of those flashpoints for many situations where people would think that, okay, well, I thought you would just do good for goodness sakes, and how can you charge my trust and take away from me, dear uncle, for compensation? So another thing that we just keep top of the mind when we're talking about trustees, choice of trustees, and their rights, their entitlements, their obligations.
Suzana, what about choosing corporate trustees? Maybe you can start with that, and then Jordy, you can chime in with your thoughts.
For sure. Just one more of the potential people who could act as trustee is the corporate trustee. And many times people just start shaking their head when we just even mention it, because they think there's this perception that they're just more expensive or too expensive. And many times it turns out that it's quite a reasonable suggestion in particular circumstances. So certainly it's going to depend on the value of the estate. It's going to depend on the complexity. And at the end of the day, it might be, based on the family dynamics and the other alternatives, the best choice for a client ultimately.
Jordy, do you have thoughts about corporate trustees?
I do. I'm a big believer in corporate trustees I believe, and you guys can speak to this maybe more, but I believe that the choice of executor of all the mundane, relatively non-contentious issues, that, like not cutting out a kid, I'm not talking about that, but of all the other kinds of decisions, that is the one, the choice of appointment that causes the most, if not litigation, bad feelings. And so I caution my clients about that, picking one kid over another kid, or who you're going to pick as a trustee. I think that decision is actually overlooked, and not enough importance is put on that as far as what kind of dispute it's going to cause and what kind of bad feelings it's going to cause. And so I actually believe that if independent trustees were picked, if there was no charge for compensation, you could pick an independent trustee every time, I would say do that. Because especially for trusts, because I just think that, there's nothing to bring people together like a common enemy. Sometimes the choice of an independent person like a trust company or someone else, just actually brings people together. And so I'm a big believer in independent trustees. I recognize there's a downside to every decision that's made, and that you don't have that personal connection, and you have to pay them. And, and as I say, a trust company is going to be more expensive than somebody who's going to do it for free. That's for sure. But it might actually be cheaper than if you hired me, where I'd seek the full compensation I'd possibly be entitled to. And trust companies typically will enter into an agreement that's less than the general guidelines that we use.
Yeah, that's the thing. If you get at it early, they'll negotiate the price, and typically you're right. It can be cheaper than picking an individual. I have to harken back to your comments about neutral. I mean, neutral is a key element to all fiduciary aspects, and the trustee appointment being neutral is incredibly difficult. I'm a big fan of podcasts, especially in this crazy time. And I've been listening to a really amazing podcast called Against the Rules by Michael Lewis. And Michael Lewis is one of the leading, well, he's a phenomenally successful writer and movies and books. And he's got, his first season is all about referees and people who try to take neutral positions. And it was fascinating listening to him because he really drew out some of the core difficulties that come with this, neutral role. And it's a good listen, and I highly recommend it. It's called Michael Lewis. It's called Against the Rules. Michael Lewis, a great podcast. Anyway, let's move on then, Jordy. We've talked a little bit about the process now. Can we spend some time now on some key clauses? You're on mute. Jordy, you're on mute. You're on mute. You're muted.
I was actually swearing at you, Ian. So that's good.
Oh, you make things
difficult. Usually I don't. See, I can't do that in the office. So this way, it's much better. But if you want to hear what I was saying, I'll repeat that after.
Well, I look forward to it.
So I talked a little bit about this, about where taking notes, and this is something that I found I developed because of a case that involved. It was a law pro case that I was working on, and what happened was there was a change between the draft and the one that was signed, and the version that was signed, and there wasn't necessarily. There was a better way, I think, of doing it. And I thought of that myself, like, oh my God, I make these changes, and how did they come to be? And when did they, did I make all the changes I was supposed to make, and those kinds of things. And so I developed this kind of client will review sheet, which I use to go over the drafts with clients, and whether we have any special discussion about a particular topic, I put that in the left column. That might not necessarily relate to a change. It might just be, look, we talked about the home trust and, and the age of the kids or whatever. And then the changes I put in the right column, and I just check them off as I go. And then I know, okay, what changes were supposed to be made, and what did I do? And so that's a useful sheet to just go back to when you want to go to the final version. You say, okay, what changes did we make? Well, here are the changes we made from the previous draft. So just wanted to show that to people.
Okay, Jordy. And so you also go through you've got your own sort of checklist at the end of your will review. Could you maybe call that up and show us that step you take?
Sure. So that's really, so as far as the checklist goes, this is basically what I'm going through and make notes on. Now, the other thing that I use to let the client compare is the graphic summary and the text summary that says, okay, now where is it in my will that I'm giving the cottage to this person or that person? And so there's that, but that's basically the client comparing. You're using that to guide them in understanding, what the overall plan was.
And what does your guide look like?
If you give me a second, I'll call it up.
All right. And while you're looking, the next question is going to be relating to the form and content necessary in a holograph will. So Suzana, can you just outline it briefly, the concept of the holograph will and some of its substantive history?
Sure. A holograph will is a will that is written wholly in the handwriting of the testator. And so that's the main requirement, is that it's be in writing by the testator. In terms of substantive components to it, I mean, it's going to be very, very specialized and individualized depending on who's preparing it. But I think the main things that we want to consider is including the appointment of an executor, someone who's going to ultimately distribute and administer the estate. And then we talk about, you know, the specific powers that come with that. If you can get that sophisticated, you'll want to include some of those. But for the most part, when people are just thinking about planning a will, they want someone to administer, so they need a trustee. They want to make some gifts, and then they want to distribute the rest of their estate. So that residue is really the key component next to the appointment of an executor. And keeping that kind of plan in mind is really crucial. And then of course that document has to be signed by the testator and hopefully dated as well.
And the dispositive clause, I think, is the key too. And do you want to just speak to that?
Those being, of course, you know, how they're going to give away their estate. So the residue, ultimately saying, you know, I want to give something to, you know, my house to so-and-so, my accounts to whomever, my investments to whomever, identifying them as clearly as you possibly can, and then catching that, you know, catch-all group of residue gifts and making sure that that's provided for as well. I see Jordy's got a checklist that he's referred to in the past and he's showing us now. That's exactly the kind of thing that, you know, we want to make sure that we're addressing. So there we have a revocation of any prior will, the appointment of an executor, paying of debts, and then ultimately dealing with the dispositive provisions of the will.
And just this is from this is the Hull and Hull blog on March the 20th that has this you know, these instructions to the client on how to do it, so that's available for sure if you're interested in that.
Terrific. Thank you both. All right. So can we go back now, Jordy, just to finish the thought on your guide? I just think it's a useful tool as well as your, you've already showed us the cross-referencing tool, but you also have a guide that you use.
Give me one moment. I'm sorry, I was pulling up the other thing. We're
Meanwhile,
back at the ranch.
I thought I was giving you time to pull it up.
Well, you did, and then you switched to the holograph thing. I thought I'd pull that up, okay?
Little bait and switch.
Very couple, I think. So I'm going to grab that. And
all right. Well, I think the importance of it is really as you grab it, is it comes back to transparency for the client. The more the client knows and understands what they actually did and where it is in the will document itself, the happier the client is at one level, and also the more effective your planning is. So, all right, I'll let you. You've got the document. I'll let you carry on.
Right. So this is just the text summary with, you know, the provisions of the will, and I can say, you know, go through this and then say to them, okay, I'll show you where this gift is in the will. Here's where this gift is in the will, and I think we've shown this a few times before, but and then the idea that and this is often, I just had a client yesterday who said, you know, send me that new graphics in there, and now that we've changed things, that's the only thing I understand. So the idea of what's you know, what's going on and where is it, you know, where are these gifts being made, and this isn't the greatest example, but you know, you could say, okay, remember you gave the country house to the kids in a trust, here it's in paragraph 6. Okay, great. And the client can even write that down on their little, on their printout and say, okay, this is where I can find this gift. This is where I can find that gift. Maybe eventually we'll be able to have that link directly to the paragraph number in the will, but right now we don't. But certainly those kinds of notes can be made. And then the client can find, oh yeah, where did the home to Sarah go? It's here. So that's that idea.
Great. Okay, just one, and this is, we're going to come, let's just, near the end, I want to deal with a couple of other questions so that people don't think I missed it, as just recent experiences with probate applications. But before we get to that though, in terms of vital clauses in the will, Jordy, many of our clients sort of glaze their eyes over when you pass on the last 2/3 of the will document with all the powers that are there. What do you do in terms of your intake on that and on your explanation of that? You know, how do you explain to a client 2/3 of this document you don't really have to worry about? We just got it there because we're being careful.
Right. So the two things. One, when I send out the draft will, it has a guide attached to it that takes them through the standard sort of provisions, as well as it highlights where the important part, the dispositive provisions are. But it basically says, okay, this power is to allow the trustee to do this. This is to do that. So it's a sample document linked to the, or sorry, guide linked to the document itself, so they can refer to the paragraph specifically. And there's that guide available as well. And I said to them, look, you know, well, why is it so long? Why is it so long? Why do you have all these powers in there? And I just usually say, look, we don't know exactly what you're going to own when you die. And most of these powers will be completely irrelevant. And nothing in here is changing who the beneficiaries are or who's going to get your money. They're administrative powers to allow the trustee to do what they need to do. And that being said, you know, we don't know what you're going to have. And so we put in things like, you know, the power to run a business. Well, I don't have a business. Well, you might have a business. And I'd rather have this in and be ignored than not have it in and need it. And most clients come around to that. I mean, the occasional client says, well, I don't want this power in there. So, okay, it's your will. You don't want it in there. So I just, on my notes, on my client review sheet, I write, you know, wants this power deleted. And I put ALA, against legal advice. Some I will. So, you know, I mean, I'd explain to them what the downside to not having it, but I mean, if it's a crucial power, like, you know, I don't want my trustee to be able to sell. I'd say, look, you know, that is something, I'm sorry, you're going to have to take my advice on. We need that power. You want to get rid of this? I'll trade you. I'll get rid of this power, but that's one we need. So that's how I deal with it. And but I don't I don't go through every line with them. I don't read the will to them as far as the administrative powers. So, you know, I'm just calling it up on my screen right now, but, you know, that is not something that I would spend my time doing, as long as they understand what's in there. And you know, and we can explain these pretty quickly.
The power to sell, Jordy, it's power to sell. I mean, I have questions on that from time to time from people. What is it why is that one that sort of jumped out at you as an important one that you wouldn't want to ever compromise?
Well, the problem is dealing with real estate, and without that power, and if you didn't have a debt, I mean, if you didn't have there's an argument if you have a debt clause, you have that power implicitly. But the problem with if you didn't have the power to sell, then the executor couldn't sell real estate without the consent of the beneficiaries. So, or majority. I mean, there's a whole bunch of rules about that, but so that's one. And I'd be like, yeah, you don't. If you told me to take that out, I'd say I'm not sure I've explained to you how this will is going to work. Like, you obviously don't understand how. I haven't done a very good job explaining how this will is going to work. So, I mean, I've never had them tell me the sale one takeout, but yeah.
All right. So, Jordy, we're going to now pivot a little bit. And Suzana, last bit of the podcast, the webinar. One is we're seeing, and I think it's more of a comment than anything else, different jurisdictions are dealing with probate applications differently. Toronto still seems to be running very smoothly in their process. But I'm hearing, and one of the questions raises that some of the jurisdictions outside of the GTA are making the probate application more difficult than it is in Toronto anyway, in the light of the fact that sometimes they're being required, a probate application has to fall into the category of an emergency, urgent matter, and so forth. Not that we can comment much on that, because I've done one in Hamilton and mostly Toronto since COVID, so I haven't really had a tremendous amount of exposure to the different jurisdictions. But Jordy, are you seeing anything from your end on the probate application side?
Yeah, I'm seeing that wills, I had one, I think, or I heard anecdotally that the court is not accepting affidavits that were commissioned on an affidavit of like a probate application has been executed virtually. So by video conference, they want, you know, old procedure used. That's my anecdotal, and I don't deal with them every day, but that's what I'm hearing from our clerks.
And I see just in the chat line that someone's having a tough time in Toronto already right now. So my experience isn't necessarily the experience of everyone, and sounds like Barry is dealing with them extremely fast. So that's interesting. Okay, so the probate application process itself is something that we're just going to have to continue to monitor. One thing, Jordy, if we could just turn back to some execution, we're deep into counterparts execution and video virtual witnessing. The OBA sent around some precedents as well, and it's interesting. The OBAs, I haven't seen it, but where the question says that the OBA's precedent says that they only recommend that the lawyer sign an affidavit and not the second witness. Is it better to have both witnesses sign the affidavits for all virtual signings, or just the lawyer? So that's an interesting point, and maybe you could comment on.
Well, I guess I wouldn't recommend. I don't know if the OBA is recommending that only the lawyer sign. I mean, I'd be hesitant to recommend that you not do it. You might say, look, like what we've said. Look, I've said, I think that you can go with just one, as long as it's the lawyer and both witnesses were in the same room with each other. Then you could probably go with one. I don't dispute that. I think though, if we're asking this question, what do you think a court's going to prefer, having both affidavits or only one affidavit? I think a court might very well take only one affidavit, but if on the off chance they get some direction that requires one from both witnesses, I'd rather have one from both witnesses. The hard one to get is not, for me at least, is not my son's affidavit that I commission. It's getting my affidavit commissioned by some other lawyer that's not in my house. That's the real problem. So why not? I mean, again, I don't think it's required. At least, I mean, they may make it required. I'm not sure that's going to be the case. And so, but if you could do both, and you can do them pretty easily, I'd rather have both than one. That's all.
Oh, fair enough. So we have another point about the OBA, and apparently, and I haven't seen it come out, but the OBA is talking about putting out some sort of virtual subscription virtual witnessing subscription platform. So if it does come out, we'll watch for it. I'd heard about it, and there had been some discussions last week, but I haven't actually seen the product. And apparently there was a tweet yesterday talking about it from the OBA. So there might be some other resources. But Jordy, I see you're calling up the non-sanctioned OBA, non-OBA sanctioned resource.
Right. And no, I'm very, I think the more information we have about this, the better. This is the one we came up with, and obviously this is the one with the licensee swearing the affidavit. And again, if you had both witnesses together, you could probably go, like I said, it's quite possible you could go with just one. But this is the harder one to get, at least for me, because I don't have a commissioner in my house, whereas I can commission my other witness, my son is usually the other witness, as his affidavit. So I'm still finding, to be honest with you, that most of my clients prefer the backyard signing to the virtual signing. I have to say it's a huge pain. The virtual signing, the will's coming back, the affidavit after affidavit, it's and exhibits and stuff like that. So it's a bit of a pain for
sure. Jordy, we just had a question, and maybe Suzana as well could make some comment. Any concerns with Zoom security for video consult and for witnessing, Jordy? Start, and then maybe Suzana.
I don't have Zoom security concerns. To be honest with you, we've been using lawyers have been using email for most of their days, and that's probably the least secure of anything. So I think there's this idea that there is some risk of bombing, but I don't see that. Sort of somebody popping into your meeting, I don't see that as a big issue. And I know that Zoom is. I just read in the paper that is dealing with a end-to-end encryption as well. So I'm okay with it, to be honest with you.
I share Jordan's views on that. Everything that I'm seeing is indicating that Zoom is constantly monitoring that and trying to make things, more protective. And I think, what's the alternative? And so to the extent that this is what everyone's doing, I think it'll also be a standard of practice issue as well. If everyone is using Zoom, then, we can't be too faulted for it. And my bigger concern would just be, the actual Zoom environment and the instructions that are being provided, and a concern over possible undue influence rather than having someone come in and Zoom bomb.
Yeah, I think I look forward to the submissions that I get to make in front of a judge on that case one day. And I think as part of my evidence will be a Zoom call that I did with that judge during COVID on a hearing.
Exactly.
But there's also some great tools using a password, and Michelle's just noted helpfully too, using on the default on Zoom that there's a waiting room, so you have to let people in, and that's another easy tool to add to your protection steps in that regard. All right. Well, look, we're coming to the end of our week 8, and unless anybody's got any other questions, if Suzana and Jordy had any other comments you'd like to make, I would suggest we move on to taking our instructions and signing our wills up. Any other comments or questions? No? Okay, great. So thanks again for everyone for joining us today. We'll be back next Friday. We've heard nothing new in terms of the any new legislation or anything, but we'll certainly be watching for the OBA resources, and any other resources that come out, we'll highlight it next week for sure. So thanks again, Suzana, and thanks, Jordy.
Thank you.
And thanks everyone else for joining us.
Thank you.
Bye now.
Have
a good day.
Take care. Bye-bye.